Okay.
So
Good morning, everyone. We'll go ahead and start our April 22nd meeting. And let's see. I'm just wondering what number this is for the meetings. Do we ever tabulate how many meetings we have or that we've had historically? But anyway, all right, we can just go ahead and do the first item on the agenda, which is the minutes.
I move to adopt the minutes.
Yeah.
Second.
Very good.
no proposed changes.
No proposed changes.
So the
I
motion.
did have just, we don't, anyway, we're good. We're good.
Aye.
Okay. All those in favor of moving to, well, we're all in favor, right? Everyone's in thumbs up. Good.
Aye.
Very good. I heard Victor. Good morning, Victor. The second item on the agenda is administrative matters. Brian, you have a report for us?
Yeah, it's pretty minimal. One thing is that Commissioner Rubin let me know he won't be here today. So I believe we have everyone we're expecting. As usual, the legislative members have conflicts. And I understand that the Legislative Council may be pulled away by business in the building. Today's meeting is likely to be short, unusually short, because much of what's on the agenda is framed as consent. So unless commissioners want to pull stuff off and discuss it, it's likely that a lot of these items are going to get approved just with minimal presentation. And in that vein, I was considering whether to suggest canceling the May meeting. We're in an interval where it's going to be important for me to spend a lot of time on administrative work, so I'm going to have a hard time producing material for our deliberations. Kristin Burford is at a stage in her work on the toxic statutes where it would be helpful for her to do a lot of offline work, trying to get answers out of experts before preparing draft language. And the fish and game study is something that we could slow down a bit without harm. We could do a lot of work offline, and also we need eventually to be working with the Department of Fish and Wildlife and the Fish and Game Commission on some of the items that require discussion. And there's no urgency in pushing that forward. So there are a bunch of items that it really isn't essential that they be heard in May. And there is work that is going to be sort of pulling me away from this. The one thing that might warrant a meeting in May is if it's necessary to take any action with respect to the legislative program. I don't know how likely that is. I think our bills have all been through their policy committee hearings now. There are a couple that are parked on suspense in the appropriations committees, but we often don't have a lot to do with appropriations anyway. So I don't know how likely that is. That's why I'm not just suggesting at this time that we cancel, but rather giving you a heads up that I might find that it would be best to set that meeting aside and get back together in June. So if that happens, I will consult with the chair and let you know.
Or I was just thinking, I mean, we can go ahead and that can be a commissioner suggestion, just to have May just be a no meeting month. I was listening to James or Commissioner McAllister talk about her sons, and I know my son, he's on the same schedule there where they tried to avoid spring break. So they're tired, and May would probably be a good month just to take a little time off. Is that okay with everyone?
If that's all right with everyone, we could easily do it.
Yeah.
All right. That's all I have to report.
Okay. And then any commissioner suggestions, or was someone going to say something?
Yeah, Brian, maybe in the future, not every meeting, but once in a while, do you want to give us an update as to what's going on with the Penal Committee?
Sure. They, they're developing their own processes that are similar to the commission's, but not identical. They're in part because I think their intention is to move at a faster clip. And so they're doing a single annual report that aggregates recommendations that they've developed over the course of the year. So rather than doing in-depth studies of the type that we do on specific subjects, they will hold meetings where they're considering particular issues, and out of those meetings, they develop proposals. Another difference between the committee's work and the commission's work is that the committee is not, in general, drafting statutory language. So their recommendations are more conceptual. And let me think if I can. So, for example, there's case law, a case called Estes, that held that a shoplifting, which would ordinarily be larceny, can be charged as felony robbery if there's force used, not to sort of obtain the item, but to escape. So you're shoplifting, you put something in your pocket, you're on your way out, the store's guard says, hey, and grabs you, and you like shove back and run. If you shove them back, that force can be sufficient to charge it as a robbery. And so the recommendation of the committee on that was to pare that back so that it would instead be charged as, Barbara, you maybe need to help me with this. There was, I think, either as a sort of aggravated larceny.
Petty theft or something like that. I mean, the main point was that if it's charged as a robbery, it can count as a strike under the 3 strikes law. It's a much more serious offense in terms of punishment than simple shoplifting.
Yeah, actually, I don't want to derail our meeting. I was just saying conceptually, maybe updates from time to time. And now that you're telling me, I definitely like to see their annual report, because since we're all on the same body, we may be asked about what they're up to. But I didn't want to interfere with the agenda here today.
No, I actually, I toyed with the idea too, because I think just we don't operate in a vacuum, and just, you know, policing and all of that is a hot item, a social item right now. But I did find the annual report on there's a link on our site, Victor, but I would recommend if we could just, if the director, just, you know, Brian, maybe just spend a couple of minutes just giving us an update, because it would be nice to know what they're working on, because it also could address any commissioner suggestions that might come up, because I was even thinking about how Commissioner Rubin might, you know, want us to kind of explore some issues. And so that, I think that would be good.
So after this meeting, I'll email commissioners a link to the committee's annual report from 2020. So you can take a look at it at your convenience. I wasn't intending to dig in and explain all the recommendations. I was just mentioning one sort of as a way of illustrating their general approach as framing things conceptually rather than drafting language, and then relying on legislative counsel and legislative authors to develop the implementing language. And so, you know, like I said, they're moving at a much quicker clip than we do, because we dig in and perfect the language. And now they're just in 2021 phase, and there are bills pending to implement their recommendations, and they are holding more meetings to discuss further issues. I think that there's a meeting in May where they're going to talk about death penalty and life without parole. So that'll be, I think, May 25. I might be getting the date wrong. So with that, I don't have anything else to report. I think the chair was getting ready to move to commissioner suggestions, and we are recycling memorandum 2021-13 on the case citation style issue.
You guys, we gotta put this to rest.
It was postponed from the last meeting because we had absences at the meeting.
No, I know. That's what I'm just making sure that we make a decision today. Got it.
Well, if you don't mind, let me restate my position and then we can take a vote. Folks, California citation style has put the date in the middle since at least 1968. All the big California legal authorities use that style. The Rudder Group, Continuing Education of the Bar, Witkin, the official statutory annotations use it. The state entities that are our audience, Legislative Council, the Attorney General, the Judicial Branch, they all use it. You might think this is trivial. You might think this is arbitrary, but it's the same as misspelling the name of the judge on your case. You look ignorant. And for a commission that's charged with correcting the law, that's bad for our credibility. And if we keep doing this incorrectly, that's willful behavior, which is worse. Now, it might be inconvenient or embarrassing to admit an error, but we're public servants and we should be doing our jobs properly, using California style. With that, I submit it to your wisdom.
You guys, are you ready to take a vote on this? I move that we vote on it. You're seconding it, Jane? Okay.
No, I had a question. I think we had wanted to check in with Ms. Jenkins about this. Wasn't that the last that we wanted to see if there were any concerns or comments that she wanted to make with respect to this particular issue, because I know that she had to leave the last time. So not to put you on the spot, Ms. Jenkins, but if there was something that we're going to contribute, we'd like to hear it before we vote. I would at least. Thank you.
Sure. So I followed up with Brian and let him know that our Ledge Council style for both our opinions and statutory citations, we do follow the California style. So, and that has been our practice. I know we started many years ago with the Blue Book style, but the California style has been in place for quite some time now. So I don't know the exact year, but it has been our practice for quite some time.
Just to supplement that, I went back through California Supreme Court opinions as far back as 1968. And that was the earliest point at which I could find that they were consistently using a date. And when they used a date, it was in the middle. Before 1968, the California courts either didn't use a date at all or they used it inconsistently.
Was there a motion on this?
Yeah.
Well, I made it one, but there's still questions. Commissioner Simpson?
No, I was just gonna move that we adopt the California style.
Second.
All those in favor, say aye.
Aye.
Okay. And all those.
God
again?
bless you all.
Okay. Yeah, I was going to say, you probably didn't have to spend that much time explaining or arguing and debating it.
Well, I didn't want this to be a subject of conflict. I would hope we could all get on the same page, and we did. So awesome.
Well, but I want mine to be registered as a nay, but it doesn't matter because it's you have a majority vote, so I think it's good.
Were there any abstentions? No? Okay, got it. Okay, that completes that item.
Okay, we'll move to the next item.
Legislative program.
Yes.
Memorandum 2021-18. So our bills are continuing to move. They're all still viable. The table that was attached to the memo shows the status as of the date that the memo was released on the 15th. There's been a little bit more progress since then. The resolution of authority, ACR 24 by Assemblymember Chow, was approved on the floor of the Assembly on consent on the 19th and is now in the Senate. The bills on the California Public Records Act reorganization are on suspense in the Appropriations Committee. That's in the Assembly. On the Senate side, the revocable transfer on death deed bill, SB 315 by Senator Roth, has cleared its policy committee and is in appropriations and is also on suspense. And the Common Interest Development Meetings bill, SB 391, has cleared its both of its policy committee hearings and is on third reading, so it'll be up for a floor vote soon. Kristin, what's the status of the trial court restructuring bill by Assemblymember Manchin?
It's for consent on the assembly floor.
Okay. And Steve, the eminent domain proposal is in the Assembly Judiciary Committee Civil Omnibus Bill, and that was approved by what committee?
By that committee.
Judiciary.
Yes, by Judiciary. So it's on its way to appropriations now in the Assembly.
Yeah. So we're in pretty good shape. There have been some amendments subsequent to the last meeting. The transfer on death deed bill, the SB 315. At the last meeting, I mentioned that there had been legislative interest in changing the standard for the beneficiary of an RTOD deed's duty to give notice to the heirs of the deceased transferor. In our original proposal, the standard was quite low. It was, I believe, an intentional, well, I'm not going to find it. The committee staff was interested in moving that standard up a little bit to make it based on reasonableness. And Senator Roth accepted that amendment, and that change was made. So now, as discussed in the memo, the beneficiary is required to make a reasonably diligent effort to give notice to beneficiaries in order to avoid any liability. But as I mentioned, there were a few tweaks around the edges of that I think soften it a little bit. For one thing, it only applies to beneficiaries that are known to heirs that are known to the beneficiary. So if there are undiscovered beneficiaries, or heirs, it wouldn't apply. And more importantly, there's a provision in there that says you satisfy the reasonably diligent effort notice requirement as a matter of law if you give notice to the heir's last known address. So even though I think basically the bottom line of the language is you're not going to be liable if you gave known heirs written notice at their last known address. So it boils down to not too onerous of a standard. And so my take is that that's not incompatible with the commission's recommendation. It's just a slightly different way of formulating a standard that the committee felt was preferable. And so my recommendation would be that we accept the change, but not necessarily revise our report to incorporate it. And with the comment that we currently have in our recommendation and the nature of the change, I don't believe that any kind of revision to our comment is required. So my recommendation would be that we take no action on it. We accept it as not incompatible, but do nothing affirmative to embrace or incorporate it. Is that okay? Okay, anyone see it differently? No? Okay. That was it for the RTOD deed bill. The CID meeting bill was also amended. It was amended first in the Senate Housing Committee, as was discussed at the last meeting, and was amended again in the Senate Judiciary Committee meeting, again with the same range of issues that were discussed at the last meeting. There was a further tweak to the rules on giving members notice of a meeting conducted under our proposed law. And the cumulative effect of both the Senate and Judiciary Committee here amendments is shown in the memo on page 3. I again think the commission should accept the legislature's preferences on the exact requirements to impose for giving notice of these meetings. They put a lot of thought into it, and Assemblymember Min has already accepted the amendments. They're in the bill now. I do think, though, that we should also revise our comment to conform to it. And the proposed revision is shown in the memo, starting at the bottom of page 3 and going on to page 4. Basically, the comment that we drafted pointed out the governing law on giving notices. It was sort of explanatory. It said meeting notices are to be given by general delivery, and by the way, members have the right to request that they be given individual delivered notices for any general delivery notice. So we just pointed that out because we weren't really changing the underlying law on the method of giving notice. Now that the bill has been amended to change the underlying law on giving notice, our explanation is kind of superfluous. We don't need to explain general law anymore because the bill has its own particular law on the issue. So basically what I'm proposing as a revision to the comment shown on page 4 is that we just strike our language that points to and explains general law on notices and CIDs. Is that acceptable?
I agree.
Any concerns? Okay. We'll make that change. And finally, there were a couple of amendments that added rules on issues that weren't addressed by our proposal at all. One is a rule for when you can use the proposed law to conduct a meeting where ballots are counted. And the other was to add a provision making clear that the general enforcement provision in the Davis-Sterling Act's meeting rules applies to this proposed law as well. Those are both things we've talked about, but we decided against addressing them in our recommendation. The bill now addresses them, and so they're sort of extraneous to what we did. And I don't think they are incompatible with what we did. We just didn't do it. And so I would again recommend that the legislature, that the commission accept the legislature's preference on these points, but that no comment revision is required. Because since we were silent on these issues, there's nothing, we didn't say anything in the comment about them, and therefore there's nothing that needs to be changed. Is that all right? Okay. Any concerns? No? That is all I have on that memo. Thank you.
Thank you. We have 8 attendees that are listening in right now, but and I think that makes it perfect so that we can go to the next item. I think most of them are here on item number 4, which is well, not 4, but fish and game. Yeah. But let's stay in order though. Number 4 is recodification of toxic substance statutes. Kristin?
That's mine. Thank you. Good morning, commissioners. So this Memorandum 2021-19 presents draft proposed legislation for the first part of the recodification of Chapter 6.5. For the commission today, the primary decision is whether to approve this draft as for tentative inclusion in a future tentative recommendation. It would be subject to change if we got any comments that we needed to adjust these provisions. But for now, whether or not this draft is acceptable, and if so, we would keep moving forward. So I'm not going to walk through all of the items that are addressed in the memo, but there are a few things that I want to mention. So what's included in the draft? This is proposed Division 44 is going to be the place where we recodify Chapter 6.5. The draft includes part 1, and the chapters that we've got are the findings and declarations. So that's all material that's from existing Chapter 6.5. Chapter 2 is the effective recodification provisions, which are standard provisions that we include that explain what our project is doing and its non-substantive effect. Chapter 3, definitions, and these are all grouped together right now for the most part in Chapter 6.5. They correspond to what's in Article 2 of Chapter 6.5. So these are the definitions that apply to the chapter as a whole. Chapter 4 is financial provisions, and these are like account provisions that pertain to the Department of Toxic Substances Control and budgeting. So they're sort of broad department financial rules. And then Chapter 5 is some general powers and duties of the department. There are a couple things that I just want to highlight for the commissioners. A lot of our drafting practices were very much the same as what we did previously with Chapter 6.8, but there are a couple things that we came across that we plan on doing consistently, and those items are listed on pages 2 and 3. I don't think there's anything controversial there, but it's things like removing extraneous cross-references to the definitions that already apply, or correcting agency names, or clarifying if we're referring to a state or federal agency, if that hasn't been done, making references to federal law consistent. So those types of things are things that we will do consistently throughout, and we will not necessarily bring up again. If the commissioners have any concerns or problems, welcome to bring those up. Seeing that, I'll just plan on using those as part of my standard drafting practices going forward. The other thing that I want to mention is there are a few items that we propose adding to the commission's list of issues for future study. So as a commission will recall, this is a non-substantive study. We're very limited in what types of changes that we can make. But in the course of doing this work, we're coming across things that seem like there might be either a minor substantive problem, or there's just an issue that we don't know that we can resolve without possibly unintentionally causing a minor substantive change. So in that vein, on pages 7 and 8, we've included some items that we would be putting on a list that will be included in the commission's report. When the commission received this assignment, they were directed to include such a list by the legislature. So for our previous Chapter 6.8 work, the commission had decided to exhaustively list the things that we came across. And I think we would I assume that we might be taking the same approach here. So that's what I've been assuming so far, although there are several items where I haven't decided as staff that we should add those things to the list, but I've sought comments. So we'll see where those things end up. The items in the memo are things that staff is proposing that we add to the list. Very briefly, those are making a couple of definitions regarding violations consistent with one another. There's 3 different classes of violations, and it seems like those rules are a bit redundant or just aren't consistent in the way they need to be. And I think that's something that could be addressed. Some of the definitions that we have come across are very lengthy and difficult to read and hard to understand. One of those definitions is for the term treatment. Trying to restate that definition just got very difficult quickly. It seemed like there were just too many changes needed that we couldn't really address in a non-substantive study. One thing that we've seen pretty consistently is that the Chapter 6.5 provisions use some terms from Chapter 6.8, and they do not necessarily cite to the definitions of those terms. That seems like a broad issue that needs to be looked at holistically to determine whether or not you could address it for the chapter as a whole, or you need to look at the individual provisions. And then finally, there was a provision that requires the department to post certain material up on their website. And that's proposed section 6700. Prior to the commission's work, there was an independent review panel that looked at the department and its laws and what it was doing. And their work actually led to the assignment of this study to the commission. That independent review panel found that these materials that the department was required to post, some of that material might be obsolete and it needed to be addressed. So that's something that making changes to that provision would potentially be a substantive change because you'd be removing a requirement that's in the law. But we want to add that to the list of issues for future study with attribution to the IRP for that idea. And so think that's all I really wanted to draw the commission's attention to. I'm happy to answer any questions. The memo does talk about a few more specific issues that we weren't sure how to address that were a bit unusual. But unless the commission wants to hear about those, that's all I've got to report. I don't know if there's any stakeholders in the audience that have anything that they want to say on this issue. So I'll just, if they do, please raise their hand.
Yeah, if there are any comments. I don't see any hands raised, though, Kristin.
So yeah, so all today I'm looking for is a commission, just a tentative approval to potentially include this in its future tentative recommendation. And it looks like I'm getting thumbs up. Is there anyone that wants to abstain or vote no? Okay. So that's all I need. I did want to mention that going forward, as with Chapter 6.8, the staff plans on preparing cumulative drafts. And so as we build this law, we'll keep putting that material together, updating the cross references and just putting that out for the commission. Typically, not something that the commission needs to talk about at the meeting, but it just kind of shows you the progress of our work. So
I think that's ideal.
Okay.
That's good.
All right. And that's all I have. Thank you, commissioners. I appreciate it.
Good. Thank you, Kristin. We will go then to the next item, which is Fish and Game.
Yeah, and Steve's going to be presenting that memo.
Okay.
Good morning, everyone. This is 2021-20, and this memo presents a second batch of proposed changes to the existing Fish and Game code that are being considered for inclusion in a draft recommendation that the staff is assembling, according to a methodology that was approved by the commission at the last meeting that includes presenting changes in different consent categories. So turning to page 2 of the memo, under the heading changes that should be made, we have this first group of consent items. These are items that include proposed changes that are either supported by both of the two commenting entities, the Fish and Game Commission and the Department of Fish and Wildlife, or are supported by one with no opposing view from the other, and which the staff recommends be included in the draft recommendation. So, as these are consent items, does anyone have any questions or concerns about any of the proposed changes listed in this category? And if not, does the commission approve including these changes in the draft recommendation? I'm seeing a thumbs up, which is great. Another thumb, okay. And I'm seeing nobody with Zoom. It's a little bit difficult. So if somebody could speak up if they either have a problem or then I'm assuming we're good. Okay.
We have one person, Wendy Bogdan.
Thank you.
And, Angela Donlin.
I will enable them to talk. And I don't want to steal their thunder, but I was going to add to what Steve said that it should be understood that while the commission is deciding to add these things to the recommendation that it's building, that eventually the Department of Fish and Wildlife and the Fish and Game Commission will need to review them as well and satisfy themselves that we've understood their input correctly. So us finalizing it does not necessarily mean that it's going to survive contact with the world. Let me activate Ms. Bogdan first, since she was the first to raise her hand. You have to unmute yourself. There you go.
Wonderful, thank you. I'm not sure that I've got any thunder, Brian, but okay. You're always welcome to steal it or even just borrow it. Thank you all. Yeah, I think we're still trying to understand how this process is going to unfold, how we can support you in the work that you need to do, given the limited resources that we have to do the due diligence necessary to endorse these changes. As I mentioned at the last meeting, which I realize probably was not your ideal process with the memo coming out 3 days before. We had not had a chance to review that given the limited opportunity for public review prior to the meeting. We're not in a position to endorse any of the actions that were taken about specific sections of the code. So I think that we really look forward to working with Brian to try to find a way that provides you the input that you need to feel like this is a collaborative process, while also respecting the resource constraints that we have. So yes, in short, we aren't able to endorse any particular action on these provisions right now.
Okay, and I was actually going to suggest, based on what Kristin had said about her study, that I've been thinking that it might be a good practice for us to also prepare cumulative drafts as we move forward on the Fish and Game comments, not as items that require any kind of action or decision at each meeting, but more just to keep everyone abreast of where we are and what's been provisionally decided. And I also think that might provide a useful resource for the commenting department and commission, Fish and Game Commission, to see concretely like has so far been provisionally approved by the commission. And I've spoken with Ms. Bognan, Ms. Donlin, whose hand is no longer up, and renewed a commitment that we're not trying to use this process to move faster than they can move. And so we're happy to continue refining it as the study goes forward to make it work, so that we can get meaningful input from those entities about the statutes that they're responsible for. Ms. Donlin's hand is up again. I'm going to enable her to speak. There you go.
Hi, thank you to the chair and the commissioners. I appreciate, Brian, hearing you talk a little bit about maybe doing a cumulative draft and referring to what the commission is doing in these individual memos as a provisional approval. And if that could be captured, I think, in the minutes in some way, that might give me and maybe Wendy and others a little bit of peace of mind that we are on this slower track than you are, that we'll still be able to comment, and that the commissioners would then have some ability, since they've only given a provisional approval, they'd have some ability to revisit those decisions if we come up with some concerns. I just want to make sure I'm understanding that.
I think that sounds right.
No, I think it sounds good too, Ms. Donlin, because we are meeting at a more frequent pace than we ordinarily would. And so, yeah, they're just basically keeping us abreast. So I think, Brian, and I know that Barbara's memo touched on it too, but I do think in these particular studies, for Kristin's study and then for Steve's study, that releasing the, just the smaller updates online is probably ideal. I don't necessarily think that for the court matter, which we'll deal with later, but that's commissioners. Oh, David Cordillo.
I just had a question about our schedule, which may affect the schedule you were just talking about. Brian, do you have any sense of how much longer we're going to A, be able to keep doing these on Zoom, and B, doing them every month as opposed to every other month?
I don't. I kind of, see the writing on the wall and think that this all might start thawing sometime in late summer, early fall. And if the need to be physically separated abates, then I suspect the governor's executive order will be rescinded at some point. And with that rescission, we would no longer have the means to do this entirely on Zoom.
So then that would mean that we'd probably have to go back to every other month.
I would think so. Just because the travel overhead is burdensome, and it's a lot to ask people to dedicate 2 entire days essentially to the commit, or an entire day every month it's hard to accommodate that. So yeah, and we'll see what happens. That's my guess, my best guess, but I haven't gotten any guidance on that.
And I think, I mean, we could look to the schools, and I think we all kind of talked to that before. Everyone is kind of looking at the fall as that's going to be the thaw point. So, you know, maybe by December, definitely we can meet again like we usually, did, but who knows?
But back on the point with respect to the Fish and Game process, I don't see any reason why we can't describe the decisions as provisional in the minutes. And nor do I see any problem with producing a cumulative draft that gathers those incrementally at each meeting, just so we can see where we've been and make sure that the commenting entities are clear on what's been done and where things stand. My hope is that it won't be quite as difficult for the Department and Fish and Game Commission to keep up with the provisional approvals, because those are categorized and approved as items where there was no dissent, right? There was affirmative support from one or both and no dissent. And so the issue that needs to be confirmed by the Department and Fish and Game Commission is that we've correctly understood their input and effectuated it in the proposed legislation. Not that there's going to be, I hope, any new issues about the merits of the change, because we're relying on what they told us in the written comments in putting things into that category, but more just that they need to do their due diligence and make sure that what we have construed as support was intended as support. And I don't think it's going to be too burdensome to achieve that, because we're being pretty conservative in how we're working through the comments. The harder task is going to be the items where, and Steve hasn't gotten to this yet, but the items where we're suggesting that issues require further attention and further input, either because there's a change we think would be a good change to make on which there was no comment, or there's comment, but we're not sure we understand it, and it just needs to be talked through further. In those instances, it's not just going to be a matter of the Department and the Fish and Game Commission confirming that we correctly understood their expression of support for a particular change. They're actually going to have to engage in the merits of new issues that we're raising. And that would probably take longer, because they're a very large department and they have a lot of specialized expertise. And so, some issues may require consultation with the people who are specialists in commercial fishing, and others with people who are the specialists in petroleum pollution in water. And so it's to be expected that they may need to wrangle the particular people who know how to answer a particular question in their department, and that's going to be more than just reading what they wrote, reading what I wrote or Steve wrote, and making sure that everybody's on the same page. So I won't be surprised if this study evolves to essentially have a fast lane and a slow lane, and we'll just have to see how that goes. There, I made a big speech. Ms. Bogdan has her hand up again. If you wanted to add more, feel free.
Oh, great, thank you. I just wanted to acknowledge Brian and you're thinking right there, and I think there's a lot of really productive room for us to find sort of the sweet spot here in our conversations over the next few weeks and months, recognizing that I think that at the last meeting things got off just a little cockeyed, and so we need to all sort of start working through this machinery, you know, kind of get the wheels turning a little bit and see how things shake out. I also really want to acknowledge Ms. O'Brien and others who have reassured us that, you know, you will be working to make sure that the schedule accommodates the kind of drawing upon the kind of expert staffing that Brian just described to work through these issues and get to the right result. And we're certainly not looking to abuse that trust, but we do want to make sure that this comes out with a product that we can endorse. And I just really deeply appreciate your acknowledgement of and willingness to recognize the resource draw that it takes to respond to these. So thank you. I heard that loud and clear, your statements at the last meeting, and I'm hearing them again now. And I really appreciate that.
You know, I just wanted to also just let, you know, any of the stakeholders on this particular study know that we, and you probably would not have seen it from our other memos, but sometimes we take comments from emails that are informal, letters that you might be able to draft. You can, you know, if there are other people that are not necessarily speaking on behalf of the associations that they're working with or that they're affiliated with, then they can speak as individuals. And we really do try to, you know, either include them in the memos or talk about them at the meetings. And I'd say that in respect of your time, because we all appreciate you being here. But if it is helpful, then sometimes you can email and you don't necessarily, especially when we do start meeting in person again, it doesn't necessarily require all the resources to, you know, shuttle back and forth to the meetings that we have. You know, you can do what you can, you know, through correspondence as well, if that's easy. And nothing as formal as our memos are, just quick emails and whatever is helpful to you. Okay, I just want you guys to be aware of that. That's one option too.
Well, and I expect that many of the issues in the memo where we note that further input is required, we are completely open to whatever degree of formality makes sense. You know, emails, phone calls, conference calls, whatever. So yeah, the chair is correct. It doesn't have to be like a formal writing that's been blessed up the chain of command, especially at that stage of the process where we are really just trying to get everybody on the same page and understanding. So Steve,
You have your hand up. Did you want to say something? I don't know if it's really up or it's just on your icon.
Who?
Angela Donlin, I just see your hand. It's not up on the Zoom screen, but
I don't see it being up.
Okay. All right.
So Steve's got more of the memo to present.
I know, I was thinking for Steve. I didn't think
that's all right. No, that's fine. So just to make sure we're sort of all on the same page, I'll ask again, and this time I will phrase it appropriately. Does everyone give provisional approval to these first batch of changes being included in the cumulative draft that the staff is preparing? All right.
I'm going to copy Commissioner Carrillo. I'm trying to get to the camera.
Okay.
It's all about the thumb.
No problem. Thank you very much. Okay, so turning to page 15, we have a second category of consent items. In this case, in this batch, we have only one item. And this category are proposed changes that either one or both of the commenting entities have not supported. They've either opposed, well, they basically, it's been opposed by one or both of the commenting entities. And the staff recommends that these proposed changes not be included in the cumulative draft and in the draft recommendation. So, I'll ask the same question again. Does anyone have any questions or concerns about this item? And if not, does the commission provisionally approve not including this particular change in the cumulative draft? Okay, looks like everybody. And then lastly, still on page 15, we have a third category under the heading of changes that should presumptively be made. These are proposed changes that we don't really need to discuss, but we can if you want. These are proposed changes the staff had been thinking is likely to be included ultimately in the draft recommendation, but we don't yet have a clear expression of position from the commenting entities. And so these items are included in things that need to be further discussed with Angela, Wendy, and somebody from the Fish and Game Commission. And we will bring these back to the commission at a later time after we've had that discussion. And that's not to say we won't be discussing all the items, but these in particular, the staff is not ready to make any kind of recommendation at this point. Does anyone have any question or concerns about the items in this category? Okay, and seeing that, that concludes this memo. Thanks very much.
Hey, Steve. Just trying to, the attendees, if you have any, further questions, then we just ask that you can present them to Steve, either through an email, or you can do it with Brian or present it to the chair, however, but you can direct them. Deborah Larrabee is here. Brian, did we want to identify Deborah as a person too that people can contact and reach out to if they have questions?
People could always talk to Deborah. If it's on the substance of a study, it's probably better directed to the attorney who's working on it. But if it's a process question about, the communications or the website or something like that, consulting Deborah is good. And no worries if you send her stuff she can't address, she will forward it to the appropriate person.
Very good.
Hi, Deborah.
Great. Let's move on to the next item, which is number 6. It's Barbara's study on trial court restructuring.
Okay, well, good morning, everybody. I am wondering, I noticed we still have some members of the audience who are here. I'm wondering if any of those people are here on this memo, because if they're not, maybe we should take the stock cooperative memo instead, and then do this one last.
Can you, okay, somewhere, Mr. Grewal, are you here on one of the studies?
Well, he can't talk.
Yeah,
He can raise his hand though.
I don't see any hands, so I don't think anyone is. But Barbara, I don't think anybody's here on the stock co-ops either. I might be mistaken about that. If anyone's here for stock co-ops, raise your hand. Yeah, I don't think so. I don't see the.
Then I think we can go ahead with this one. I just didn't want to keep people waiting when it was unnecessary to do that.
No, I appreciate it.
Okay, so today's memo addresses a set of provisions that were removed from the Commission's 2001 tentative recommendation on trial court restructuring for further study. And this is a group of statutes that relate to representation and indemnification of trial courts and trial court personnel. There are 6 code sections in this group, and the memo discusses them in numerical order because coincidentally, which was nice, that happens to be a logical way to approach them. The first code section in the group is section 811.9 of the government code, which was added to the codes in the year 2000 as the trial court restructuring reforms were ongoing. And it made clear that judges, subordinate judicial officers, and court executive officers are state officers for purposes of the Government Claims Act, and that people working for a trial court are considered employees of the trial court for purposes of that act. The section also made the Judicial Council responsible for providing for representation, defense, and indemnification of judges, court officers, and trial court employees. And it directed the council to adopt court rules requiring the Judicial Council staff to manage claims and actions involving the trial courts, their officers, and their employees. As originally enacted, this code section applied to both the superior courts and the municipal courts, but a 2005 bill that was sponsored by the Judicial Council removed the municipal court references and made various other tweaks to the provision. In addition, an earlier bill, a 2002 bill, revised various provisions in the Government Claims Act to specifically address claims against courts and court personnel. So the current version of Section 811.9, which incorporates the updated provisions of the Government Claims Act by reference, this version of the statute reflects both the legislature's views and the Judicial Council's views on how representation, defense, and indemnification of trial court personnel should be handled in the restructured trial court system. And importantly, the section expressly applies notwithstanding any other provision of law. In other words, its requirements and the referenced provisions of the Government Claims Act are apparently intended to override any contrary law on the subject. So as best the staff can tell, Section 811.9 does not contain any material that's obsolete due to trial court restructuring. And our advice to the commission would be to leave this section alone. Does that sound acceptable to the commissioners? Does anybody disagree with that or want to abstain? Okay. The next provision discussed in the memo is Section 990.2 of the Government Code, which relates to ensuring a trial court officer or attaché. It is part of the Government Claims Act. In the 2001 tentative recommendation on trial court restructuring, the commission proposed to amend this section to refer to former municipal courts instead of municipal courts. And the tentative recommendation also included an accompanying note which solicited comments on whether the Judicial Council or the local superior court should be authorized to insure against liability of court personnel instead of or in addition to the county. And in response to the tentative recommendation, the Los Angeles County Superior Court and the Contra Costa County Superior Court expressed concerns. So the commission removed the proposed amendment of Section 990.2 from its proposal for further study. The comments from Los Angeles County Superior Court and Contra Costa County Superior Court predated the bills, the 2002 and the 2005 bills that were sponsored by the Judicial Council that I just mentioned, which deleted the municipal court references from Section 811.9 and clarified and solidified the Judicial Council's role in handling claims against trial courts and trial court personnel. And given those developments, the staff now suggests amending Section 990.2 as shown on pages 5 to 6 of the memo. The proposed amendment would remove the reference to municipal courts that's now in the section and would give the Judicial Council authority to insure officers and attachés of the Superior Court instead of the county. And so the first question here is whether the proposed amendment that's shown on pages 5 and 6 is acceptable to the commission.
There's some feedback. Is that, can the commissioners make sure you just cut off your, I guess everyone's off though. Or Bridget, maybe, I don't know what that sound is. Do you know what? Oh, anyway, Barbara, go ahead.
So is the amendment shown on pages 5 and 6? Does anybody have any concerns about that? Commissioner Simpson wants to say something?
Yeah, no, no concern. I think it looks fine. I was just curious. I never, what's a court attaché?
It's
I never heard that term.
we have done research on that in the past, and I hesitate to try and summarize the research. I can tell you that it's a bit complicated, but basically someone who works for the court.
Okay. I think your suggestion is fine.
Okay, and then the second suggestion here with regard to that section is that we would also suggest including an accompanying note soliciting comments on whether the Judicial Council actually needs the authority to ensure as provided in the section. It may be that they don't need that authority, in which case the provision could be repealed rather than amended. And so we suggest including a note that just asks the question. That also acceptable to everybody? Okay. Let me just. Okay, so the next.
I think that's you. When you turn a page, it brushes up against your microphone, and it sounds like a plane going by.
Oh, I'm sorry. Okay, no, I had no idea. So the next provision discussed in the memo is Government Code Section 26524, which is not part of the Government Claims Act, and it directs a district attorney to represent a superior or municipal court or a judge of such court upon request by either a municipal or superior court judge, if the court or a judge is in official capacity as a defendant in the matter. And the commission proposed to repeal this section in 2001 because it appeared to have been superseded by section 811.9, which was the provision we just discussed at the beginning of this discussion. The commission did not receive any comments on the proposed repeal of section 26524, but nonetheless removed, just in being cautious, removed the section from its 2002 proposal because it wanted to look at the other provisions on representation, defense, and indemnification. Subsequent developments that we just discussed seem to confirm that the provision probably has been superseded by section 811.9, or at least that the Judicial Council is now responsible for finding representation when a trial court or a trial court judge is a defendant in a case, instead of having such a judge directly request such representation from a DA. So the staff would suggest, again, proposing to repeal section 26524 as shown on page 7 of the memo, but also including a note that asks for comments on whether there are circumstances under which the Judicial Council might want to provide for representation or defense through a district attorney, and if so, whether section 26524 should be amended to permit such representation on request of the Judicial Council instead of on request of any judge of the Superior or Municipal Court. So this would be, again, an approach where the commission would propose the reform, but also include a note soliciting comments on a specific issue. And are there any concerns about that proposed approach? No, okay, all right, good. Then going on to the next provision is simply a provision, this is on page 8 of the memo. It's section 26529. And this one, we would, if the section we just discussed, if section 26524 is repealed, then this provision refers to section 26524 and would require a conforming revision. And so this is just a question of whether to propose the conforming revision. And I see no concerns about that and assume that's uncontroversial. So then the next one is section 27647. It authorizes a county council to represent a superior court or a superior court judge in specified circumstances. In the 2001 tentative recommendation, the commission proposed to repeal this section. The accompanying comment said that that was because of the enactment of section 811.9. And the tentative recommendation also included a note explaining that the provision had appeared to be superseded by section 811.9 and solicited comments on whether it should be preserved in any form. In this case, the LA Superior Court objected to the proposed repeal. They said it continues to have practical application, that county council might be the desired choice for representation in some circumstances, and that the scope of section 811.9 does not extend to all actions in which the court or its employees are represented, and the authorization in section 27647 should be preserved. And so Contra Costa County Superior Court also objected to the proposed repeal. And like Los Angeles County Superior Court, that court expressed some concern that Government Code section 811.9 might be narrower in scope than other provisions for representation and defense, including this particular one, 27647. In light of those objections, the commission withdrew this section from its 2002 proposal for further study. And looking at it now, as explained on page 10 of the memo, it does seem possible that the scope of this provision is broader than just applying to claims under the Government Claims Act. For instance, well, I gave the examples in the memo. I don't know that I need to repeat them here. And there is also the section 811.9 says that the county council may, but is not required to provide representation or defense for the judicial council. That statement is a little ambiguous about whether it's really just talking about the judicial council as an entity or whether it's talking about the judicial council and other judicial branch individuals and entities that the judicial council is responsible for providing representation for. Most likely, I think the latter interpretation seems probable, but it's not for sure. So there's really two choices here for the commission, I think, or perhaps there's some variant on them that you might come up with. The first choice would be to propose to repeal section 27647 as the commission did back in 2001. The other possibility would be to propose an amendment like the one that's shown on page 11 of the memo, which would preserve the section to some extent, but recognize the Judicial Council's key role with respect to representation in matters governed by the Government Claims Act. The staff isn't sure. Commissioner Carrillo?
Oh, yeah, I didn't mean to cut you off, but when you were done with that sentence, I was going to suggest that the commission consider taking up the suggestion that's on page 11. That seems to me to be consistent with the general move here towards consolidating some discretionary authority over this subject in the Judicial Council. So I like the suggestion on page 11.
And what did the other commissioners think on this one?
I concur. I think in the event that the sort of circumstances under which the court or a judge might need representation or may be broader than the Government Claims Act. So I think your suggestion, leaving it in place, and your suggested amendment, I think makes sense. My only less than substantive comment was that it wasn't addressed in the memo, but since I happen to have another commission hat I wear, in subdivision B, paragraph 3, where it says any proceeding before the Commission on Judicial Qualifications, that term has been outdated since 1976 because it was amended by a voter initiative to change it to Commission on Judicial Performance. So just as a techie matter, you might want to just edit that. But
no, I should have caught that myself. I'm glad you brought it up, and yeah, we would certainly want to make that revision if we're gonna.
I sit on CJP, so I was sort of drawn to them.
Yeah. With that revision, do we have a motion?
Yes, except I object to Commissioner Simpson bringing his personal knowledge into this proceeding. Shame on him.
Yeah, right.
Yeah, no, that's what we're supposed to be doing, you guys, is while we're quiet, whatever, and that's you, the new commissioners, especially, you guys have such a diverse background. If you see something, share it. That's what we're here for. And then I agree. I like what was proposed, Barbara. So I think you have a consent. We're all agreeing anyway. Yeah. Jane and Victor, you guys are good too, right? Yeah.
Okay. Then the last provision discussed in the memo is section 27648. It's also, I think, the hardest of them. It applies when a judge is entitled to representation pursuant to section 825, section 995, or section 27647. But there's a declared conflict of interest, so the judge has to retain separate counsel. What the section does is to give the judge a right to reimbursement of reasonable attorney's fees, costs, and expenses in those circumstances. In the 2001 tentative recommendation on trial court restructuring, the commission did not propose any revisions of this section. Instead, it just reproduced the section in the tentative recommendation and included a note that pointed out that it would require revision if section 27647 was repealed. The commission's just decided not to propose to repeal section 27647. But the note also asked whether the commission should be, whether the section should be repealed due to the enactment of section 811.9, continued with revisions in section 811.9, or otherwise revised. In response to that note, the LA Superior Court said that at a minimum, any amendment of the code section must preserve the principle that a judge otherwise entitled to representation, who has to get his own his or her own representation due to a conflict of interest, is entitled to reimbursement unless that principle is implemented elsewhere in the codes. And the Contra Costa County Superior Court agreed, but urged the commission to extend that principle to all court staff, not just judges. And again, the commission took the proposed, didn't include it in a 2002 final recommendation. It turns out that a broad reimbursement requirement along the lines suggested by Contra Costa County Superior Court already exists in the Government Claims Act. That's section 996.4, which is shown on page 13 of the memo. Given the existence of that reimbursement provision in the Government Claims Act and the language in section 811.9 that makes the Government Claims Act applicable to the judicial branch, section 27648 might be obsolete with regard to at least two of the three types of representation it mentions: the representation pursuant to section 825 and representation pursuant to section 995, both of which are within the Government Claims Act. And so then the last type of representation that's covered in the section is representation pursuant to section 27647, which is the one that we just discussed. And perhaps the approach that seems appropriate here to go with the amendment of section 27647 that you just discussed would be to propose an amendment of section 27648 that limits the scope of that provision to representation pursuant to section 27647. So that's a possibility, and I'm interested to hear what the commissioners think on this one. Commissioner Correa?
Thank you. What's the argument for 4.8 still being necessary, given that, as you point out, 996.4 seems to provide the same, if not even broader coverage, because it applies to all public employees, not just judges specifically. In other words, why do we need the section specifically granting this kind of coverage to judges specifically when all public employees are entitled to it? So what's the argument for keeping 4.8?
Because the provision that is the broader reimbursement provision is part of the Government Claims Act.
So what?
So may only apply with regard to claims that fall within the scope of the Government Claims Act. And as we just discussed, the whole point of keeping section 27647 is that its scope may be different than just claims under the Government Claims Act.
What would it cover that the Government Claims Act doesn't? Because the Government Claims Act applies to any claim for money or damages against the government or its employees. So
what we just discussed with regard to 27647 was, this is in the middle of page 10. Section 27647 includes, for instance, any representation authorized by section 68111, which says that whenever any judge of any court of the state is a witness in official capacity as a judge in any action or proceeding, the judge shall be entitled to be represented at such action or proceeding by a counsel of his choice. And, presumably that would include representation of a judge, say, who is summoned to testify in a criminal case in the judge's official capacity, like if a member of the public was accused of stealing a juror's purse from the judge's courtroom. That doesn't seem to fall within the Government Claims Act. And then LA County Superior Court also pointed out that courts may contract for county counsel services pursuant to section 77212. And the nature of that kind of contract, it's not entirely clear to me what kinds of representation that could involve, but it could potentially involve negotiating, I think, a business transaction relating to the courts, like court space needs, that kind of thing. Again, I don't think that would fall within the scope of the Government Claims Act if it's negotiating the contract as opposed to dealing with a claim against the court for one reason or another. I don't have a lot of expertise with the Government Claims Act.
I do have a substantial familiarity with it. Here I am bringing my own personal experience into it. My practice when I was doing that substantially involved Government Claims Act claims. So all of the examples that you or LA Superior are raising, they seem to me to be a stretch. They're at best edge cases, and even then there are things that, to me, I would classify them as claims for money or damages, which means that they're covered by the Government Claims Act, which means that they're covered by the representation provision. So I don't know, I'm interested in what everybody else thinks, but it seems to me like 99% of the coverage that's necessary is provided by section 996.4. And to the extent that it's not, obviously that's something the Judicial Council could include in the scope of the representation that it allows counties to negotiate with, their local county council or whoever. I don't know. What do you guys think?
No, LA does use county council a lot, like its own, like a separate private firm. So no.
Right, I get that. So my question is,
and there's lots of volunteers. We have all kinds of stuff, me included.
How would that change if we took out 27648?
Because they're not included in the Government Claims Act. You could have a consultant come through. They have all kinds of different private people that walk through the courts and provide services, that use the services. We've used the services. We wouldn't, if we would have had any issues, we were using the Department of Corrections when we met in LA. It's there because some of the facilities are leased. It's not, it does seem like it would be directly like brought under, like first, definitely like in Sacramento, it would be a Government Claims Act no matter what, but LA is just different. So I think probably San Bernardino might be the same way too.
So I'm wondering that if, there's nothing wrong with a court contracting with whoever they want to provide legal services, county counsel or your personal law firm or whoever. But given that the statutes that we're concerned with here concern indemnity for wrongdoing, I'm not sure that making a change to these statutes would affect a court's ability to do the things that you're talking about.
No. So if you have people for it, you could have janitorial services that come through. They don't negotiate necessarily. There are lots of gaps in operations so that you could, like, you're right, David, in a nice, normal world where there's contracts that would address indemnification and hold harmless, there seems like this would just be superfluous. So, but in LA, yeah, I agree with them. There's too many different courts that are managed by the presiding judge for that courthouse, and no one knows what's going on in one court versus another.
I don't see how. I'm sorry, go ahead.
No, even one area. And LA is the largest in the country.
No, I get that.
And it is not, it needs to be, the resources need to be better managed and to make sure that everyone knows what's happening. But honestly, we can't, people don't get it right. And so I agree with them. This is a catch-all.
How does 27648 affect any of that? Because all it seems to me to concern is the ability of an individual judge, not the court itself, but an individual judge to recoup expenses for hiring counsel if they need to. That seems to me to be completely different than the court as an entity contracting with lawyers to do any of the things that you just
It's a
mentioned.
catch-all. It's a catch-all that they don't, but.
I think it's the other way around. It's not a catch-all. It's something very specific.
I don't know. I do think that whenever we get opposition from other parties, I just don't, we don't ordinarily argue with them that their opposition doesn't make sense. We just don't touch it. And it's just because it's the nature of our commission. We are here to provide forms and substantive revision when we can. When there is opposition or it creates political controversy, we back down. And it may not be, necessarily satisfying in terms of making legislative headway, but it is the nature of our commission. We are nonpartisan, and we, try to, we can present other suggestions. I mean, Barbara's done this beautiful memo, and they still they took opposition to removal of it. So for that reason, I would vote.
Yeah, we're still at the stage of not even having a tentative recommendation for, there was the tentative recommendation long ago, but there hasn't been any recent attempt to deal with this. So Commissioner Simpson?
Oh, I'm just wondering whether it makes sense in this circumstance. I mean, my instinct is sort of be careful about belt and suspenders. But maybe have asked staff if we were going to amend 648 to conform to 647 or whatever it was. Getting comments on this. I mean, because I guess the last comments we got preceded earlier amendments to 811.9, and as to whether there are circumstances in LA County, Contra Costa County, wherever, where a judge, I guess, is this just a judge would need reimbursement? Anyway, whoever needs reimbursement for something outside of the Government Claims Act. I don't know. I never dealt with the Government Claims Act, but to find out whether there are circumstances where something not within the scope of the Government Claims Act might be eligible for reimbursement of expenses. So we so we could solicit comments on whether that kind of thing is actually a real factor or not.
Yeah, I would agree. Soliciting more information and comments. And Barbara, there are things that maybe you need to look into. The Government Claims Act doesn't include California Whistleblower Protection Act claims. The Government Claims Act doesn't include FEHA claims.
So, the stage that we're at here is we're just in the process of trying to draft. I mean, this is the first memo on this topic, and we're trying to draft a tentative recommendation which would go out for comment. And what I could do, if you want to approach it this way, I could prepare for the next meeting a draft of a tentative recommendation that includes the reforms that you have already discussed, and would have a cover memo that maybe includes some further discussion of this particular provision, or the one, and perhaps the one that precedes it, because they're to some extent interrelated, and try to find out more about whether this really does go beyond the scope of the Government Claims Act. And, we could either put off decision on how to treat this particular provision in the tentative recommendation, or is there a particular approach to it that you'd like to take, like me to try and implement if we do prepare a tentative recommendation for the next meeting?
I don't think we're ready for a tentative recommendation, though. Right. Yeah, I didn't think that you had to do it. That was something that I definitely wanted to talk to or to discuss.
So your preference would be to hold off and prepare a tentative recommendation that's broader in scope, that includes the judicial benefit provisions as well?
Yeah. Because I think your attention on this from the stakeholders is they're not going to track it closely, and you're gonna, I don't think it will be the best use of resources for the commission.
Barbara, is there a way that you can, I don't want to say provoke, but draw comments, explanatory information from the stakeholders? I'm just curious as to what the objection is. I want to understand it.
Well, I mean, their objection is 20 years ago, so,
Maybe we could update that.
Well, I think that's the point of our tentative recommendations in general is to.
Well, if we put in the tentative recommendation repealing 648, that might get their attention.
There's often been sort of a tension within the commission. Some commissioners feel that taking sort of an aggressive stance in terms of like repealing or revising a provision, something that will provoke comment, is a good way of proceeding, because that will get people to pipe up and say what they want to say. And then other commissioners over the years have taken the perspective that if you don't get it right or close to right the first time in a tentative recommendation, it tends to turn off your stakeholders. They get upset, they're worried, they lose confidence. And so you have to be careful, very careful about what you do put in a tentative recommendation.
What do you think is the best way to solicit the information we're looking for?
If I chime in here, provoking commentary by threatening appeal 648 is not, it's not going to happen. We don't do stuff like that. Look, during mediation confidentiality, we had a very active group of judges come and visit us, telling us what the judges think about that topic. I would think that the judges are concerned about 648 as well. So as we did with mediation confidentiality, we get comments by soliciting comments from the stakeholders with the most interest, and those judges, that judges group would be one of those. But we can't go around repealing things to get their attention.
And I do think, and I'll just say that, I do think Commissioner Carrillo was being
devil's advocate. Okay, all right.
Yeah.
I
just want to hear from people. How do we do that?
Remember that
we'll
judge
hear.
that came during mediation confidentiality? He said, the judges want this, the judges want that. Well, do you want to be reimbursed for legal costs under 648? That there are groups out there that we could call and say, hey, we need you to come chime in on this.
Yeah, and we do that by, Barbara's right, through the tentative, by releasing, a tentative recommendation. So,
but there's nothing wrong with just actually writing them a special letter and saying, you may overlook this in the normal crush of emails. Please, this is about reimbursement of judges for legal expenses.
Well, we would hear from them on multiple issues, and we just haven't been. So what we do is flesh the issues out with us, and that's what I would prefer. And then we present a tentative recommendation when it's, at least when it is. But this is, it hasn't been. We haven't been working on this one for too long, so I just don't think there's a lot to provide in an interim. Go ahead, Barbara. I'm sorry.
Well, this is just this is just the first memo on this topic. So
yes, it's not ready. It's not right yet.
Is this something where we could just, in addition to doing our sort of normal, we roll stuff out for folks to look at, maybe just reach out to CJA or the Alliance or somebody
that sounds like what Victor was suggesting.
By the way, this thing is an issue we're looking at, and if you we'd be interested in your views if you want to weigh in.
Yeah, I could easily get in touch with CJA and the Judicial Council. That they track all of these memos, but their contacts there, I could send a special email and seek.
Knock, knock. By the way, we're looking at this. Yeah,
that would be super.
So I will.
I was going to add that since we canceled the May meeting, we've got a longer than usual interval, and it might be that they could get back to us in a couple of months. It's often hard for organizations to speak with any kind of authority if you don't give them enough time, but 2 months might be sufficient for an informal inquiry.
So perhaps the commission's decision here on this particular one is to, for the staff to reach out to groups like CJA and the Judicial Council and try to obtain some further input before the commission makes a decision, even as to how to handle this on handle it for purposes of a tentative recommendation.
Right.
I think that's good. And then we could also revisit whether, because if depending on what kind of response you get, then it may be very clear that then we need to put out an interim, summary of what we've done so far to solicit more interest or to help people track it if they, if any other items are raising issues that we hadn't really taken the time to. You guys, Barbara, you're wrapping up.
Yes, I think so.
Because I think the other two people are definitely on for the stock co-op, but I also think we might just want to take a 10-minute break before, or do you guys want to push through? Yeah, we need a break.
I think the stock co-ops is a 2-minute topic, potentially.
Can we take
You guys
5?
want to try? Do you guys?
Fine.
Yeah, and you know what? If you need a break, then just put your screen up and then just run away, and it's okay. And we'll hopefully catch you when you come back. Okay.
So did the commission decide that they don't want to go forward with a tentative recommendation now? I guess so.
Yeah, let's put it off until when we meet again, and then we'll find out what kind of response you get.
Yeah, make the informal inquiry and see what we get.
I think it's good.
All right, 5 minutes, 10 minutes.
Well, you said we only had a couple of minutes. Oh, you do want you want to go through, huh, Jane? Yeah, and Victor too. We have a quorum. Can you hang in there, Richard? No. Oh, you're good. Okay, let's go forward then.
So it's memo 2123, and this is the stock co-op study. And at the last meeting, you saw proposed legislation that had been prepared for inclusion in a tentative recommendation. Nobody had any concerns about it. This memo presents a completed tentative recommendation, meaning that in addition to the proposed language, there's a narrative explanation that precedes the legislation. I don't have any new issues to draw your attention to, so the only decision is whether or not to approve that draft as a tentative recommendation for public release. I would recommend that you do.
Jane motion, I'll second.
Yep, I motion.
All those in favor say aye. Aye.
I don't think we have quorum though, do we?
Yeah, we do.
We don't need a quorum we have a once a quorum, always a quorum rule. David's
there we go.
Aye.
Okay, we're good then.
Okay, I don't see any dissents or abstentions. Commissioner Kubas, you are present. Good. We just voted to approve the draft tentative recommendation. Okay.
You're okay with it.
That's it. That's all that I have. That's the last item on the agenda, I believe.
All right, then you guys, I think then we'll go ahead and call this meeting a wrap. Then we'll go ahead and you guys be safe. See you in June.
Yes.
In June.
June.
Thanks,
All right,
everybody.
thank you, everyone.
Bye, everyone. Thank you.
Thank you. Bye.